Let's go for it's crazy. I wish no, I know. Then we have a master of advocacy. And I did my January starting in June. So it's my third year of university.
Okay, no,
No, to change. They changed it. For example,
we have been like you can start the practice.
after you graduate. Now it's a change. We were still like that, but now it's
And you have 2 years more. That's why you
so you have to get a letter from a lawyer that you're working with.
no, I mean it's just 6 months. You have to take 6 months. So then it's like another year. And then you finish the practice like in January. Okay. So
First of all, I'd like to apologize. I found this seminar lecture quite challenging. As at this morning, I was still writing it. I'm happy to say, in the end, I was able to sort of get out about 30 pages to set out my thoughts in a way that I think does justice to the topic from what I consider to be a corporate governance perspective. So the easiest thing to do, right? The easiest thing to do is simply give you chapter references from a textbook. Gower would be a classic, right? Gower talks about the derivative action. And that would be a one-page document, and I could easily do this a week before. But that's really not what I want to do. What I want to do is not look at any sort of company law topic from a company law perspective. This is not a company law class. I want to look at it from a corporate governance perspective in a way that would resonate with anyone outside sort of the corporate law academy, and therefore look at things from a sort of functional perspective. And this sort of, if you look at a topic where I talk about action, not voice, in other words, how does an activist shareholder respond to agency cost within a firm? The usual way would be to do what they call the Wall Street walk, i.e. you sell your shares, right? And you invest in another company. It might not be always straightforward where you have a massive portfolio. So because you might take a hit. That could be one way. Another way could be to start some kind of protest going. So a lot of voice, right? Some kind of protest about the company. Again, when we look at the procedure for calling meetings, for tabling resolutions, we see that this is not usually very effective. NGOs, tried this with Shell, and companies like Greenpeace will do that kind of activism. It does work sometimes, but not always. So the emphasis really should be on action. What kind of action can we take? So this is where I then say to myself that, if as lawyers we're advising shareholders who wish to be activists and who are not happy with what's going on in the firm, what kind of action can you take to redress wrongdoing? So this is the context. Action. What kind of action can you take? And I suppose here again I thought about it this way. There are three types of firms we need to keep in mind. One would be a small private company. One would be a large company listed on the market, a UK registered company with a premium listing on the market. The third will be a foreign company that has transported itself to the UK. Remember when we talked about contractual corporate governance? So a foreign company gets listed. Now, so that foreign company may have block holders, right? They may have block holders. So if you take a foreign company, say from, I don't know, Malaysia, Indonesia, Ukraine, it has block holders. It then secures a listing on the London market. Then there could be oppression, right? There could be oppression because it has a block holder. It's not your typical UK listed registered company with a dispersion of shareholders. Now, in these three scenarios which I've just captured, we've got to look at what kind of action can we advise from a legal perspective, right, to deal with the problem of agency cost or minority oppression. Notice I collapsed them now. So if it's the second one, if it's a typical UK registered company with a premium listing on the market, the problem is likely to be agency cost, i.e. the directors are lining their pockets. The directors are paying themselves huge compensation packages. The directors are probably negligent, right? That would be a typical agency problem. If it's the first one, the first category, i.e. a private company, a small private company, where ownership and control are united, right? The people who own the company are the ones who control the company. Then the problem is likely to be minority oppression, because maybe it's a family company and some other person joins the family company and the family company never pays a dividend. Then you feel locked in, right? So when you describe the same act of wrongdoing, right? You know, in the private company, we would use the language of minority oppression. Let me give you an example. So, give you an example. You know, so a private company employs a relative, and the relative is demonstrably incompetent, and they pay the relative a huge salary. Now, if I'm a shareholder in that family company, I'm not a member of the family, but if I'm a shareholder, I would say, you know, I am oppressed by the majority. That's the language I'll use. I am oppressed by the majority. Why? Because of the kinds of things they're doing. They are wasting money, diverting part of our income stream to a relative, rewarding bad behavior. So the language would be that of oppression, right? Now, the legal claim, actually, the cause of action may be the same if it is a larger company, but would use a different language. So imagine it's a listed company, right, where this goes on. And you are advising an institutional shareholder. You will not use the language of oppression. You would say there is agency cost. So if you want to sound sophisticated, you would say there is agency cost. And someone said, what does that mean? Well, the agents of a company are, you know, being negligent, engaging, you know, in related party, you know, activities, right? So you use the same line. You use the language of agency cost, right? And then in the third scenario, remember? The third scenario, so remember, just in case you're not writing the scenarios, let me just make it very clear. I said scenario one, private company, small private company with a family interest. That's scenario one. Scenario two, listed company, UK listed company. Scenario three, listed company from abroad, right? With block holders. So a Ukrainian company with majority Ukrainian shareholders, block holders, listed on the London market, right? Those are the three scenarios. And I say our central aim in this class is to deal with bad behavior, right? Through action, not voice. Action, not voice. And then I said, the way we describe this bad behavior will depend on the type of company. So if it's the private company, scenario one, we would say, oh, there's minority oppression. If it is the second one, where you have a UK listed company, we would say agency costs, right? Because in scenario one, it's the majority shareholders who are oppressing you. In scenario two, it's not the majority shareholders, the agents, the managers, the directors, right? And then in scenario three, where it is listed, but you have block holders, guess what? What language do we use? What language do we use to describe it? No, I've given you, between the two examples I've given, between the two languages, agency cost, minority oppression, what language will we use? Yeah.
I think it would be minority oppression.
Yeah, and that's what I thought you would say. In fact, when you said prejudice, it's another term to describe. So when you paused, I'm thinking, why is he pausing? You know, yeah, it's minority oppression, right? That's the way you describe it, and I'm happy you got the point. It's minority oppression, right? So, meanwhile, let's really be. I really want us to get a grip on this, right? Because, this is why the document is long, right? It's not the way the books look at it. The books simply say there's a chapter called derivative action. There's a chapter called unfair prejudice, right? That's a typical company law way of looking at it, right? But what we've done is sweep all that to one side and say, actually, we're interested even in foreign companies that have a London listing. We want to know what goes on in there, how do we describe it, and what will be the legal response. So there are two things. How do we describe what's going on? how do we respond to it legally, right? So far, what we've done, we've identified a problem. Remember the problem, I've been given a very simple one. Somebody, the MD, brings in a relative, pays huge salaries, rewards bad behavior, right? If somebody says to us, how do we describe it, we'll say, what type of company, right? So we identify the company and we simply use minority oppression or agency costs, right? Then that's how we describe it, maybe at an academic conference, right? And then when it comes to litigating or preparing a legal opinion, another reason why I was a bit delayed this morning, I had to try to get a legal opinion out whilst trying to conclude this. And again, apologies for that. So when it comes to preparing a legal opinion, you're thinking about the legal tools. What legal tools should we use to deal with this particular problem, right? And that's what we're going to talk about today, right? So now, one of the points and perhaps let me just flag up the legal tools, right? I'm going to go deep into it, but I just want to plant the idea in your mind before starting. So with scenario 1, private company, the legal tool that I will be thinking of, if that client walks into my office and describes a problem, and I've looked at the problem, I know what the problem is, the girlfriend, boyfriend, friend, whatever, relative scenario, overpaid, making mistakes, right? That's the problem. I would simply say, well, because it's scenario 1, I should be thinking of unfair prejudice, right? The unfair prejudice provisions in the Companies Act, which is what you said when you were talking about the nature of the problem. That would be the legal issue. I would be looking at Section 994, which I'll talk about, and we'll see why we'll go to Section 994. On the other hand, if the same problem were described in a public listed UK company, I would not think about Section 994. I will think about the derivative action for the same type of problem, the same type of scenario. Employment of a relative who is demonstrably incompetent, who has received a lot of money, I will think about the derivative action. Notice, same problem, different remedy. If it's the third one, the third scenario, what do we do? Can you think about it? Any ideas? Just any ideas about the third scenario? What do you think? What do you think? Just guess anything, just come up with anything. What do you think? Or what do you not think? Maybe that's a better way. What would you dismiss? It's either you give me one or you dismiss something. All right? So you get points for dismissing, for saying definitely it's not the answer, or you get points for telling me what the answer would be. So I'm talking now about the same type of problem, the employment of a relative, demonstrably incompetent relative at a huge price. So we've described the problem. In the third scenario is a foreign company listed on the London market. What do we do? Yeah? Unfair prejudice. But it's a foreign company. How can you apply foreign law to a foreign company? So how can you apply UK law to a foreign company? It's not registered here, right? So you're not going to apply unfair prejudice. It's not registered here, right? You're going to apply the listing rules. Remember we talked about relationship agreements. When I talked about contractual corporate governance, remember the seminar on contractual corporate governance, I think seminar 5 or thereabouts. When we talked about contractual corporate governance, and we talked about foreign companies coming to the UK, and I said, what do we do? And I even gave you an example. I told you about some legal work I did for an Indian company which came to the London market. Remember, the example, in that case, a director had guarantees, right? So the director had certain guarantees. And The director was then coming to the London markets, and these guarantees were still there. So the director is saying, I want to have control over the company because I face financial risk because of these guarantees. And I was then advising the director to enter into a relationship agreement, right, with the company, to enter into a relationship agreement whereby you promise not to oppress them. You promise to treat the company independently. Remember? I always give these examples so that it's etched in your minds, or at least it becomes easy to retrieve it. And I hope you remember. Right? So in that case, we will say, have you signed a relationship agreement? Right? Have you signed a relationship agreement under the listing rules with the company, whereby you treat the company independently? Right? And if you're going to treat the company independently, right, you will not put in your relative and pay so much money to the relative who is demonstrably incompetent. So notice, the same problem in three different scenarios leads to three different remedial responses. In scenario 1, private company, we're talking about section 994. In scenario 2, public company, we're talking about the derivative action. In scenario 3, public company from abroad, listed on the UK market, we're talking about the listing rules. In these three scenarios, we are focused on these, these actions, right? Not voice. And so now you see the challenge in trying to put this seminar together and trying to capture all of this, put it together and supply some coherent framework that makes it understandable. Yeah, you have a question.
So this is in case of small private company.
In case of what?
In case of number 1, small private company.
Yeah.
So derivative action is not. So you didn't say that.
You'll see why I will not go there. Now there's no law. There's no law that says you can't use the derivative action in a private company. There's no law that says it, right? There's no law that says it. So I am not saying. In fact, I'm happy you raised this question. So maybe let me sort of fine-tune it. Remember now, this is just high level. I'm going to dig deep. Right? Now, there is no law that says you cannot use a derivative action in a private company. But you will see why, generally speaking, you will go for the unfair prejudice remedy. Likewise, there is no law that says that in scenario 2, you cannot go for unfair prejudice. Right? But again, you will see why in 9.9 times out of 10, it has to be a derivative action. Right? Then the only one I would speak about with 100% certainty is scenario 3. I thought you were somewhere else. Okay, are you following? Okay, scenario 3. In scenario 3, there, where you're dealing with a foreign company, I can say, with my hand on my heart, that there will be no unfair prejudice. There will be no derivative action, right? Because UK law is not extraterritorial, right? Right, so that I can be certain of. Okay, so this is high level. And does everybody understand this high level picture? Because once you understand this high level picture, then the rest is just the detail, right? And then, and I don't want us, I try not to sort of start by getting us lost in the detail. I want us to keep the high level picture in our heads, right? Okay, now, so what I'm going to start with is the first thing to do is sometimes, I want to call attention to something the government did recently. People are talking about corporate governance in private companies after the Sports Direct fiasco. And the government says, okay, you know what, let's set up a committee, we need to look into this, let's do a consultation. And the government does not focus on this problem of whether you call it agency cost or minority oppression, right? The problems that shareholders face in these companies. The government does not talk about it. The government is really more concerned with stakeholders. So notice, we're talking about the same problem, corporate governance, And the government says, well, you know, we're interested in stakeholders and owners, but when it comes to the detail, nowhere do they mention this problem. Nowhere do they mention this problem. So in other words, the government is not concerned about oppression, minority oppression in private companies. The government does not seem to be concerned about minority oppression in those category 3 companies, foreign companies which come to the London market and are oppressed. The government is not saying anything. So here in the introduction, and I'll be fast here, you see, I said in August 2017, there was the government report on corporate governance reform, right, which was a response to the Green Paper consultation. The government fails to consider minority oppression as a corporate governance issue. And I said this omission is glaring when we consider the importation of oppression. Notice, the importation of oppression through corporate governance, contract for corporate governance from abroad, right, by blockholders that obtain a listing in the UK market, right? And I remind you about contractual corporate governance, right? We're flowing. Okay, and then I said this is what the government stated in its report, so I give you extracts. The government believes that the case has been made for strengthening the corporate governance framework. Corporate governance framework, you think it sort of covers everything. For the UK largest private companies. That they take a responsible approach to corporate governance and that they are running their business with regard to the wider stakeholders, right, stakeholders, but it goes on to say, as well as owners and shareholders. By the way, who are owners, who are shareholders, and they're the same, right? So you see loose language, right? Actually, if I were to write this, I wouldn't even say owners, I'll say shareholders, right? Because no one owns the company. People have rights in the company. And that depends on the kind of rights, right? So that gives us a clue that it's not rockets. They're not rocket scientists writing these things. Government is us, as competent or as incompetent as us. But anyway, so in paragraph 3.27, you see the government saying, we expect the FRC, the Financial Reporting Council, to develop a new principle for UK corporate governance code, right? And it goes on. The point basically is that it does not talk about this subject. It's focused on general corporate governance for, you know, what I call the value question. Remember, I've always said in this class that corporate governance is about structure, process, and values. Values, remember, values connects with section 172, right? What are the values that underpin the company? Are we going to be sort of a loving company, take care of the environment, love the polar bears, that kind of stuff, right? So you see that what the government is focused on is this, right? And what I would do is now is upload the weights report. You know, the weights report is the end result of this, right? Because the government basically appointed to the FRC to look into this. FRC basically says to weights, can you give us a code, yeah? A code which will apply to private companies. So this is, you see here, it says, the government will introduce secondary legislation to require all companies of a significant size to disclose their corporate governance arrangements in their director's report, including whether they follow any formal code. The formal code is the weights code which the government knew was going to come out as a result of the FRC's guidance document. And remember, last time we met, we looked at directors reporting, right? So remember, we looked at Sainsbury's, we looked at Lloyd's, where they basically were reported. Now, private companies will have to do this of the relevant threshold. So you're talking about a company that employs more than 2,000 people. But the point here, the point I'm making, is that nobody is talking about minority shareholder protection, whether you define it as an agency cost problem or a simple minority shareholder protection issue. Okay, so here I say the omission of the problem of oppression. The government does not focus on oppression as a corporate governance issue. And I say the oppression remedy, the unfair prejudice remedy, is a key instrument of corporate governance. And we see this in the Clientus case. Now, I've mentioned the Clientus case when I talked about Dragon's Den. Remember, in class, I've talked about Dragon's Den, where you go to pitch your idea and your business ideas, and there's this guy called Theo Perfitis, right? Theo Perfitis is one of the dragons in the den, and so Theo Perfitis is a guy that people respect, seen as a guy with a Midas touch, that kind of stuff, big profile. unbeknownst to people, in a company of which he was director and shareholder, somebody, La Senza, the La Senza people, if you don't know it, it shouldn't be in this class. But anyway, so the La Senza people basically came with a business proposal to sell their lingerie business to Theo's company. Theo's company refused. Basically says, no, we're not interested in it, even though Theo's company was in the lingerie business. So they turned it down. And then Theo, who they brought it to, took it privately, right? So he took it privately. So you'd expect that, it's almost like, I can't remember Theo's company's name now, but try and imagine La Senza comes to me, Victoria's Secret, and says, we're selling lingerie. You would expect Victoria's Secret to say, yeah, this is a way to increase market size. And then Victoria's Secret says, no, won't touch it. And then the director, the MD there, then takes the business. And then, by the way, goes back to his company, Victoria's Secret, and says, please give us money. Give us a soft loan to do the business. That's exactly what happened. Theo takes money from his company and basically steals this corporate opportunity. This is what you'll call tunneling, right? He's taken a corporate opportunity from the company. And a shareholder. Now, we know that there is a breach of duty, right? You've taken a corporate opportunity from the company. What section are we talking about? Don't worry, section 175, right? Because 175, you take advantage of your position, right? You take a corporate opportunity. Theo is not dealing with his company. Theo gets wind of a corporate opportunity and then takes it. So section 175 would apply. So clear breach. But the fact that you get a breach is not enough. You need to go to court, isn't it? So the question then is, remember we're talking about action. What kind of action can you take? We know that there's a breach, but how do you get to court? So if you were to advise Theo, you would say, this company, is it a listed company? Is it a private company? We know it's a private company. It's not a listed company. So what would you do? Now, remember, I said to you, I would say, go on the... Sorry? Unfair prejudice. Exactly. In this case, what happened? No, a less competent lawyer advised them to go for the derivative action, right? I'm being flippant when I say less competent. I think there's a reason why they said go for the derivative action. They went for the derivative action because when you bring a derivative action, the company gets to pay your lawyer's fees. Right? The company gets to pay because your action is derived from the company. So the company pays the lawyer's fees. That, I believe, was the real reason. So they brought a derivative action, and the court said, so notice, now the issue is not whether or not there's bad behavior. There is bad behavior, that's not the issue. We know there's a breach of 175. The question is, what is the best way to get into court? You see the court there basically saying, this is the wrong action to bring. And we're going to look at why it is a wrong action. But just one way of testing it. The court is saying, if you bring a derivative action, and you say Theo made, I don't know, let's imagine Theo made £10 million from this, and you pay the money to the company. Because Theo is a majority shareholder, right, he can the next day pass a resolution to pay a dividend. And if he has 70% of the shares of the company, he will the next day get 70% of the £10 million that he just paid to the company. Do you get it? So who will benefit? Only the lawyers. Because Theo will get his money back, right? The lawyers will get paid. You, the minority shareholder, what have you done? What have you done? You have killed your company with kindness. That's what you've done. You've killed your company with kindness. You've basically got your company to pay out money, right? And to what purpose? To what purpose? So if you truly want this action, if you truly want to bring about the end of this bad behavior as it affects you, in other words, if you want to stop this oppression, what should you do? Go on the 994. Pay your lawyers, your own lawyers, pay them, and go to court and say, you know what Theo is doing is unfairly prejudicial to my interest. I want out. I don't want to be oppressed anymore, and I want Theo to buy me out. And when you buy me out, value my shares on the basis that that corporate opportunity was never lost, right? So we'll calculate the value of the company on the basis that the company got the licenza contract, right? So the company was rich, and you then buy my shares, and I make my money, and I go elsewhere. You get it? Yep.
As a shareholder, would he have still received the majority?
Would he?
Would he still have received the majority of the money from the deal?
But if it's a majority shareholder and you pay a dividend, the dividend goes to everybody based on the number of shares you have.
Okay.
Do you see? So he captures it. The payment of the dividend has nothing to do with whatever he did. You don't penalize. You don't say, oh, because you were bad, you will not receive dividends anymore, right? Okay. Did you see? You see how we've kind of worked at this. So, and so here, what I do here is simply quote some paragraphs. The defendants all argue that, so the directors, Theopiphitis, they're arguing that, not just Theopiphitis, the directors on the board, right? They're basically saying the claimant could pursue his complaints more appropriately by a petition pursuant to Section 994. Remember you asked me, could you bring a derivative action? I said, well, it's possible, but in 9.9, right? Sorry, yeah.
Sorry to interrupt, but I'm actually not accustomed to the English procedure, and so I understand the logic, and I understand the explanation is right, but I mean, so anyway, I think Section 260 of the Company Act does not limit the qualification of the complaint, and that in such cases the court can dismiss this complaint.
Yeah, okay. So when you say dismiss the complaint on the, so what would the claimant be doing?
I mean the statutory law does Section 260 does not does not limit the qualification of the plaintiff.
Yeah.
In such cases, the court can dismiss the claim of this kind of class action.
No, okay. So basically, you're quoting the provision on derivative actions, right? Okay. You're basically saying that that the claim can be dealt with under the derivative action, and it can also be dismissed, right? Under the derivative action. Isn't that what you're saying?
Yeah.
Okay. Yeah, it can be dismissed. Yeah. Okay. That's what happened. It was dismissed.
Yeah.
It was dismissed here, and they said, go under 994, right? But the word is, it can be dismissed. That means it can also be received, right? And that's why when you asked me that first question, I said, there is no law that says you cannot maintain it, right? But in most cases, it's going to fail, right? Now, the reason, I'm just giving you the reason why the judge said, go under 994, that it does not make any sense to do this under the derivative action, because guess what? The guy will get the money back, right? I've just given the one reason. I'll come up with a framework to decide how we make that choice, right? Remember, I'm just discussing one case, and I'm telling you the reason for this case. Now, this reason may not apply to every other case, right? In this case, we know who's going to get the money, right? But it may not be in another case. So what I'd like to do as we go along is give you the framework. That's what I call the detail, so that you know, right, by law, what would work. Okay. So here we see the arguments. So you see the court basically saying here, in all circumstances, I agree with Mr. Todd that the availability of an alternative remedy, they're saying you have an alternative remedy. The alternative remedy is 994, right? In the form of an unfair petition is a powerful reason to refuse the derivative action, to refuse 260. So basically, to touch on your point, we are refusing you permission to bring a derivative action, right, under 260, because you have an alternative remedy. And we've worked out that this alternative remedy makes sense. Okay? So, now, Now, why did I mention this? So that I said the omission from the government report of oppression in light of the fact that we still see oppression in private companies, right? Because if we tell that shareholder, who brought this action, were you oppressed or not? He's going to say, I'm oppressed. Did you succeed in court or not? He's going to say, I did not succeed, right? Because he's going to say, how do I fund an unfair prejudice action? They're very expensive. So if we were to speak to this gentleman today, and we talked about the government report and said, hey, guess what? The government is coming up with a report to deal with the problem of oppression in private companies. He's going to say, great. And when he reads the report, he's going to say, this doesn't take care of me, right? Because guess what? I suffered oppression. I went to court. There was no doubt that there was a breach, but I couldn't bring this action. The courts were telling me to go under 994. But who pays my bills under 994? Maybe if the government had said, one way we're going to sort of deal with this is to look at the problem of the cost of 994 petitions and who pays, then we'll be going down the route of finding a solution. Is that clear? Okay. So here I talk about the inadequacy. Notice the story continues. So we're telling this guy, was this case in your favor? And he says, no. Why? He says, the derivative claim is inadequate for me. It's not a panacea. It's not a panacea. So, when I lost that case, that was the end, right? So, and then here, what I do is to say, so here we're dealing with, we're now leaving the micro. The micro is the guy, right? Intelligent people don't base their conclusions on the experiences of the individual, right? You try to look at the macro. You step back and say, what the hell is going on? Now, when we step back and we look at the macro, you look at empirical research in the area, you see a picture. And what's the picture? Nobody is bringing the derivative action. So you come and read about it in law school. In practice, it's not happening, right? So here I refer you to these papers, right? And I'm happy in a way. It's good that we're looking at this now, so that when you read the papers, everything falls into place. Because if you have all these papers and you kind of read them and you don't really understand the construct, then you get lost and you don't sort of understand how they fit together. So when you read Amo's paper on private enforcement of corporate law, an empirical comparison of the UK and the US, you're seeing that they're telling us that the derivative action is not working. They say we find, based on a comprehensive search for filings over 2004 to 2006, that lawsuits against directors of public companies alleging breach of duty are nearly non-existent in the UK. The annualized number of lawsuits filed seeking damages against directors of publicly traded companies in the UK is effectively zero over our sample. And to be sure, they looked at the position in the United States. Right? Again, similar picture. Slightly more litigation there, but similar picture. The upshot is that while directors of publicly traded US companies are much more likely to be sued under corporate law than their British counterparts, lawsuits under corporate law are hardly an everyday occurrence, and out-of-pocket liability is scarcely to be feared. So what this means is that when we talk about lawsuits, when we talk about the derivative action, we see that there isn't much going on as far as the derivative action is concerned. So maybe 996, 994, 996, 994, 996 is the remedy, is the panacea. Maybe we need to go back. Maybe this is what the government should have been doing, right? Do you see? Can you imagine if you were to write to the government, all right? When they were doing the consultation, as matters, one is very busy, and because I remember when I read it, I thought, there's a gap here. So assuming I had the time, that would be one of the things I'll be saying, you know, that maybe we need to try to see how to, you know, in a sense, reform 994 so that it becomes a bit more viable, right? Because there's really no hope with the derivative action, right? It's 994 we really should be looking at. So from the above, it is clear that as far as shareholder litigation is concerned, the petition for unfair prejudice appears to be, at first glance, the only effective remedy. The only effective remedy. Because remember, the court in Cleanthus said to the shareholder, why not use 994, right? But we know that he could not have used 994 because he didn't have money, right? And you know why 994 is so expensive? If you're going to say, have you ever, you know, for those who have seen marital squabbles, you know, oh, you didn't do this, you're unfair. You know, once you use the language of you're unfair, there's no time limit. They go 10 years. 10 years ago you did this. 5 years ago you did this. So there's no, you can't sort of have a time limit to say, hey, you know, you did this yesterday, and that's why I'm responding. Instead, you know, oh, when you were doing this, you know, 10 years ago you did this. Right? Now, what does this mean? Once the allegations are many and they go way back, litigation becomes expensive. Because the moment you have these allegations in your pleadings, you've got to prove them. Right? That means witnesses have to be there. Witness statements have to come in. You're going to cross-examine them. It's expensive. This is why these cases are expensive. For you to say, for this guy to say there is oppression, he may want to not just confine himself to what has just happened, i.e. the taking of the La Senza deal. He would say, you know what, this happened before. It happened before and all that, and lead all that evidence is going to be expensive. So you discover that in a lot of cases, the amounts you pay your lawyers are by far more than what you're trying to get, right? And so this is it. This is the problem. There's another reason why 994 cannot be used. So remember now, we're talking about the Category 1 company. So let's shift it to Category 2. Let's shift it to Category 2. Because remember, in the paper by Armour, they looked at publicly listed companies, right? So that's Category 2, isn't it? So if we look at Category 2, you will discover that you cannot bring a 994 case within Category 2. You can't bring. Now, there's no law that says you can't bring it, but why do you think you can't? So, let me put it this way. So the remedy in 994 is not viable in the context of a listed company, right? And why is it not viable in the context of a listed company? When you go to court under 994 and you're saying, I have expectations, right, that have not been honored. Notice, you didn't say I have rights. You said I have expectations, right? So you're saying, I have expectations, I have interests, not rights. If you had a right, it would be a direct action, right? You know, if I have a right to vote and the MD of the company locks me out from voting, right? He locks me out. Then I will sue the MD, right? And say, you're breaching my personal rights. I have a right under the articles to vote and you have thwarted it, right? So I will sue to enforce this. But if, on the other hand, you're negligent, you never pay a dividend, right? So you're negligent. You've never paid a dividend. These do not affect my rights. They affect the rights of it. In fact, I would say one of them affects the rights of the company. Not paying a dividend does not affect anybody's right. It doesn't affect the rights of the company. The company gets more money, right? But certainly not paying me a dividend does not affect my right because I have no rights to a dividend. I only have an interest. So if that's the case, if I go to court and say to the court, protect my interest, where will the court find the interests? You see, under 994, the beauty of 994 is that it allows the court to see things that are normally not visible. There are things that are outside the range of judicial vision normally, right? These are things like the things you told me in the pub when we had beer. You told me in the pub that, you know what, you can be the chairman of the company. You told me, you know what, you can run this company and I'll be sort of laid back. Those are things that are not written anywhere. They're not in the shareholders agreement, they're not in the articles and all that. So in the case of a small private company, no problem. There's no problem enforcing that, right? Because the courts would search for these understandings. They will search for these interests. In the case of a listed company with thousands of shareholders, the court cannot do that. The court can only go by the book, right? So if the court is going to go by the book, then it's going to have a hard time protecting your interests under 994 if you are a listed company. So in these three cases, and you only need, if you want to find it out, if you only need to read, let's say even the last one, or the Aztec case, Tottenham Hotspur, Aztec is the last one, 1998, right? Because the last one refers to the previous ones. And you see the court's basically saying exactly what I've just said, that, you know, in a listed company, we can only go by the public documents. So for this reason, I said it becomes necessary for us to put less emphasis on 994, right? Because 994 is only useful for Category 1 companies. Do you see where we're going now? So if we stop here, we say, what have we learned so far? 994 is useful for Category 1 companies, right? Private companies. It is not useful for Category 2 companies, right? Because, you know, the court will not find any interest or expectation worthy of protection because it's not in any document with thousands of shareholders. And it certainly does not apply for Category 3 companies because they're foreign companies and we can't apply UK law to it, right? And this is here, this is the point. I said this is important. So here, notice, when I talk about block holders, I'm referring to Category 3 companies. I said such companies with block holders carry the risk of oppression as the primary corporate governance problem, right? What we call principal problem. You see, the normal problem is the principal agent, the agency cost problem, principal agent. This is principal, right? And I say here, in such cases, Section 994 will not apply for the reason mentioned earlier, and also because the company in question is likely to be a foreign company, right? So now we know this. I think it's pretty clear now that we know what law to apply, and I would just say a few things by way of the framework of the law before going on to the derivative action. We'll take a break at this point, and then when we come back, I'll start from here, where I'll just talk about the framework so that you understand legally why one works and not the other, right? So let's take a 10-minute break. You take your coffee, we'll come back and we'll continue. Thank you. I want to get a coffee. Okay, yes.
ist noch extrem viel mehr als Exploitation. Die Leute, die dort draußen sind, das ist
Okay, so here, I mean, so far we've just been talking without reference to the law. What I want to do now is talk about the law. But in talking about the law, I'd like to give you a more sophisticated way of reading statutory material as opposed to just sort of reading sections and trying to memorize the sections. It's always good to understand the logic underpinning statutory material, and that way we get a better understanding of it. So rather than sort of take you through 994, and I start by just trying to take you back to our function of company law framework. If you remember at the very beginning, I talked about the function of company law, and I said company law had a number of functions. One of them was oppression reduction. And oppression reduction comes from the principle of majority rule. Majority rule itself comes because company law is aiding us by displacing the principle of unanimity, right? Which would normally apply, so it replaces unanimity with a majority rule principle. Now, and that's just helping us. It's kind of helping us to prevent holdout behavior and such like. So in displacing unanimity and using a majority principle, the door is open for oppression, right? Because the majority can always oppress the minority. That's how we have the problem of oppression. Therefore, since company law has, in a sense, brought this about, it's the business of company law to deal with its own mess, as it were, right? So company law has the business of eradicating, or at least controlling, oppression. So I said the risk flows from majority rule, and we see this risk in every area where the majority can exercise power, such as when they attempt to alter the articles. So when they alter the articles, right, the law says, to alter the articles, all you need is 75%. That's all the law says. All you need is 75%. But we now know, when we read the case law, that the judges have added to that 75% requirement that the operation has to be bona fide for the benefit of the company as a whole. That language, bona fide for the benefit of the company as a whole, is aimed at controlling oppression, right? The reason why the judges read that in to Section 21 in cases like Allen and Gold Reefs of West Africa, Gambioto and WCP, Citco, the reason why the courts read that in was simply because they wanted to control oppression, right? Because they know where oppression has come from, right? Now, members, I say here, members often reduce oppression by ex-ante bargaining. When you see members concluding shareholders' agreements, what do you think they're trying to do? They're trying to solve the problem of oppression. When you use a shareholders' agreement in a private company, right? So if I were to join a private company tomorrow, I'm not going to say, oh yeah, I'll rely on 994. I'm going to say, you know what, I want a shareholders' agreement, because what a shareholders' agreement does is restore the lost rule of unanimity, right? It restores the lost rule of unanimity by requiring my consent to everything. And that way I can sleep peacefully at night and not have to open one eye as I lie down in bed. So we use shareholder agreements to do this. This is ex ante. But, not everybody is loaded enough to think about, paying lawyers to have these ex ante provisions. So what company law then does is come up with a standard way, ex post, of solving the problem. And that standard way is Section 994. So I said one function of company law is to reduce oppression in the very context where it arises. And we have two remedies for this. The first one is the winding up remedy. We never really talk about the winding up remedy because, it's like, killing the golden goose, which, the goose which lays the golden eggs, rather. So we kind of focus on 994 because that's what courts basically do. However, 1221G, the winding up remedy, the thinking behind it has led to the jurisprudence in 994. So what is unfairly prejudicial conduct? So you'll see the case law. So if you look at the law simply says unfairly prejudicial conduct. But what exactly is unfairly prejudicial conduct? Right? So the case law here is this. We go back to Section 1221G, where so once upon a time, when we had 1221G, before 994 ever came in, we see Lord Wilberforce say that the foundation of those words lies in the words just and equitable. Notice it's ecclesiastic language, just and equitable, fairness, you know, it affects the conscience. And he says the words are a recognition of the fact that a company is more than a juridical entity. What does he mean there? He's saying a company is more than the articles of association, the memorandum, that in the company, submerged within the company, are things that are usually invisible to people, right? And what are those things? The interest, the expectations that people have. Remember my discussion in the pub about, you know, what I would do in a company. Those things are now visible, right? So the words just and equitable tries to protect this, and this is what he's saying. The words are a recognition of the fact that a company is more than a mere judicial entity with a personality in law of its own, that there's room in company law for the recognition of the fact that behind it, amongst it, there are individuals with rights, right? But he didn't stop at rights, because if he stopped at rights, he could then force it by direct action. He says, with expectations, right? And that these are not necessarily submerged in the company structure. Now, that is what this jurisprudence allows us to give effect to. And therefore, he's saying that this jurisprudence allows us to subject the exercise of your legal rights to equitable considerations. So I have a legal right to vote, right? I have a right to vote. It's in the articles. That's not an expectation, it's not an interest, it's a right. And we then have a discussion in the pub. And in the discussion, I say, you know what, you will be the chairman of the company, and we'll pay you X amount of money, blah, blah, blah. Now, these are not rights, right? Because to be a chairman is an outsider. It's an outsider right. It's not a legal right. Now, and then, you know, later on, I then change my mind. I then vote against it. You then say, I've been oppressed, right? I've been oppressed because I mortgaged my house, invested in this company, in reliance on the discussion we had in the pub. And now you've changed your mind, and what can I do? You've exercised your legal rights by voting. So the court basically says, we will subject the exercise of those legal rights to equitable considerations. So when you voted and you were exercising those legal rights, we're now going to hold your hand and say, no, we're not going to allow you vote this way. We're going to subject it to equitable considerations. What are those considerations? The discussion we had in the pub. We're going to affect your conscience. We're going to stop it. Right? So this is what he's saying. That as equity always does, enable the court to subject the exercise of legal rights to equitable considerations. These are considerations of a personal character arising between one individual and another, which may make it unjust or inequitable for you to act in that particular way. By so doing, we see the power of this provision. So when we look at 994, 994 is so powerful because it allows the court to protect everything. Right? And then when we look at the other case, which was decided on under what is now 994, we see Lord Hoffman in Sol Harrison saying that in deciding what is fair or unfair for this provision, it is important that we're using it in the context of a commercial relationship. So he's saying, keeping promises. You made that promise in the pub, keep that promise. Right? And the beauty of this is this. Go back to my first example. I'm a director. I employed my relative who is demonstrably incompetent, and I paid him lots of money. It's all wrong. It's a breach of duty, right? But you, the shareholder, cannot sue me, right? Because it's a breach of the company's rights. So you can't sue me. And now, you can't bring a personal action, right? I owe you no rights or no duties. If you go under 994, you can go to court and say, keeping promises is important. When the guy became a director, he made a promise. He was going to work for the company. He was going to be a fiduciary agent. He was going to be loyal. He has not kept that promise. Because he has not kept that promise, it affects my interest. Notice what we've done. We've taken the company's right, and by this kind of alchemy, we've made it an infringement of my interest, which is justiciable. Right? So when I go to court under 994, I am not saying to the court that enforce the company's rights. I'm not saying that. I'm saying enforce my interests. And how do I get the court to enforce my interest? I say, well, look at the language of 994. It talks about unfairly prejudicial conduct. What this guy has done has amounted to the breach of a promise. What promise? He made a promise to the company to serve the company loyally, to comply with Section 175, 172, not to me, to the company. He made those promises. But keeping promises are the hallmark of commercial fairness. Since he did not keep the promises, then that is unfair to me. It's unfair to my interests. Submerged within this company structure, beyond rights, are interests, our expectations. And I want you, under 994, to protect it. And that's what the court does. So the answer to this question often turns on the fact that the powers which the shareholders have entrusted to the board are fiduciary powers, which must be exercised for the benefit of the company as a whole. And if the board, if the director, steps outside the terms of that bargain, they are acting unfairly. By this, what we've done is liberate that rule that basically says shareholders cannot sue, right? Because the company is a separate person. We've liberated it and we've made it our own. Now, with 994, it's so powerful, every shareholder can sue. Do you see? So if I invest in a company, I don't need to worry about separate legal personality, that the duty that you studied, they're all owed to directors. I don't need to worry about Frankfurter J's statement in U.S. and Chenery, where he says to call a man a fiduciary is the beginning of analysis. To whom is he a fiduciary? And then the answer is to the company. And the consequence is, therefore you cannot sue. Now I know I can sue. Do you see? Now I know I can sue. And that then means that every time a client walks into my office and he tells me about a breach of duty, I don't worry about separate legal personality. I don't worry about the derivative action. I simply say, you know what, we can make this work under 994, but do you have the money, right? If you can show me the cash, we can make it work under 994, right? Okay. But notice, he says here, there are cases in which the letter of the articles do not fully reflect the understandings upon which shareholders are associated. The letter of the articles do not fully reflect the understandings upon which shareholders are associated. Think about the example of the pub. You told me in the pub, if you mortgage your home and give us some money, you will be the chairman of the company. It's not reflected in the articles. It was just a statement. And on the basis of that, I did it. And now you are not respecting this. So notice, this is not the first category of cases I talked about. The first category would be where you breach your duty, right? You employ somebody who is demonstrably incompetent. You breach your duty. And then I am able to sue because I've said that you made a promise to the company to serve the company loyally, right? And I say keeping promises is a hallmark of commercial fairness. Therefore, what you've done is unfair. I call this the Category 1 type of case. The Category 2 type of case is where you have not breached your duty as a director. We had that discussion on the pub. You didn't breach it. All you've done is ignore the promise you made to me, which involves, by the way, no breach of duty. You said, I will make you chairman. What does that mean? It means when we want to appoint people, I will exercise my votes to appoint you chairman. And then when that time comes, I refuse to vote to appoint you chairman. And then you go to court. Now here, you're not saying to the court that he has breached his duty, because there's no breach of duty. You're simply saying he has acted inequitably. He's acted, unfairly. He led me on, right? He led me on. I took steps, and now he's residing. And you know something? He's residing legally, because he's saying, you know what? I have the power to vote. Okay, and so what? We make you director today or chairman tomorrow. I also have the power to remove you, right? I have those rights. So when you go to court, you say to the court, in this second category of cases, you're saying, exercise your powers under 994 and prevent this. Hence, we see here that there are cases in which the letter of the articles do not fully reflect the understandings upon which shareholders are associated. Thus, the personal relationship between the shareholder and those who control the company may entitle him to say that it would, in certain circumstances, be unfair for them to exercise a power conferred by the articles upon the board or the company in general meeting. So notice what we've just done. We've identified two categories of cases. One, I call it bad behavior, breach of duty cases, right? It allows us to sue. Then the second category of cases, there's no bad behavior in terms of breach of promises to the company, but there is a breach of an understanding to me, right? Again, 994 allows us to, right? But you can see that this can only apply in a small company. If you have a company with listed shareholders and a listed company with 1,000 shareholders, you can't have the category 2 type case. You may have the category 1 case, right? Because the directors made a promise to keep, right? So you could do that. So I suppose the question would then be, why are you going in a category 1 case, where there is a breach of duty to the company? If the court says to me, okay, there's a breach of duty, but why are you bringing a 994 case? Why are you not suing under the derivative action? I could say that, I don't want to sue under the derivative action because, I'm not sure the courts will give me permission, right, to bring a derivative action. So that's why I'm suing under 994. And if the court then says, well, there are all these cases, re Tottenham Hotspur, re Blue Arrows, where they said we can't get 994 in a publicly listed company, I probably would say, well, those cases do not say that you can never get it. It never says never. You never say never. It never says you can't get it. It simply says that we can't use 994 to protect interests when those interests are not common to everybody, right? And that would be the kind of interest in your category 2 type of case, the promise you made in a pub. It does not cover my interest, which everybody has, for good behavior, such as complying with the articles. What I'm trying to protect is in the articles. Everybody can see it. It's not hidden, right? So there is no law, so you can tell the judge this, there's no law that says you cannot apply 994 in a publicly listed company so long as the interest you're trying to protect is an interest common to everybody, right? And then in that case, it'll be fine, right? So, and then finally we have O'Neill and Phillips, which simply reaffirms this. O'Neill and Phillips would be a case I would ask you to read. Because in a sense, it's the last word on this jurisprudence. It basically reaffirms everything I've just said, right? But I would say it's the last word to read on this jurisprudence, right? So I hope you understand what we're saying now. I hope this is clear. That 994, when I think of 994 conceptually, right? I mean, there are two ways you can read 994. You can read 1,000 cases, and literally, I mean it, up to 1,000 cases have been decided on the 994. Everybody goes on the 994. You could say, how do I learn 994? Can I read 1,000 cases? And I'll say, no, that's a waste of your time. The best thing to do on the 994 is to understand the conceptual structure of it. And I would say the conceptual structure would be these two categories. A breach of the rights of the company, which normally we would say that is the enforcement of a company right, not a shareholder right. But this time around, when you go into a 994 court, you convert the breach of the company's rights into the breach of your interests. And the way you do it is say, directors have a duty to keep their promises to the company. The failure to keep promises has affected my interest. Because it affects my interest, it's unfairly prejudicial. I want a remedy. You get it? So that covers many things, because potentially every breach of director's duty can be litigated. And then the second category of cases on the 994 involves no breach of director's duties, but simply people making promises to you, and you're trying to enforce it. Now, you can see that potentially this jurisprudence is so wide that if we're not careful, we could use this jurisprudence in an exercise of distributive justice as opposed to corrective justice, right? What do I mean? You know, when you do distributive justice, you're looking at things and you're saying, this is not fair, and it's not fair for some people to earn so much money and some people to be poor, you know, let's distribute, you know. So number one, we talk about distributive justice through taxation, you know, system. We use the tax code, all manner of credits and all that to sort of equalize things. So we're not even thinking about equality of opportunity, we're just looking at equality of outcome, you know, affirmative action, whatever stuff we're talking about. That's about distributive justice. Corrective justice has nothing to do with this. Corrective justice is simply about correcting bargains, right? So the question for a judge is, what promises did you make? And I want to keep those promises, right? That would be the issue for a judge. What promises did you make? Whereas, just a minute. I'm trying to do two things, and then you brought a third. At that point, I couldn't cope. So let me just get. Okay, yeah. What was your question?
For the second category of cases.
Sorry?
For the second category of cases, so
Yeah.
breach of promise.
Yeah.
Like the pub situation.
Yeah.
Are there situations where the judge would be just like tough luck? I mean, there's no contract between you. There's no, or is it just purely on the basis of equity?
Yeah. So it would be.
Like it's your fault that you believed him, kind of thing. That you
Yeah.
believed the chairman.
So the answer, that's a very good question, by the way. Essentially, the judge would be looking to see that there was truly a promise. So if there was no promise and you thought there was a promise, right, then that's not enough, right? There has to be a promise. And your question, the reason I said it was a very good question was because that was exactly what happened in the case I just mentioned. I'm referring to O'Neill and Phillips, right? So in O'Neill and Phillips, they thought they had a promise, but in fact there was no such promise. Okay, so let me. So if you look at examples where 994 has been invoked, you'll see that there are quite a lot of them, right? So here I give so many examples. But the key thing to bear in mind is that it is a versatile remedy, right? So I'm saying to you, yes, look at the examples, the areas where it's been invoked, but it's more important to understand the structure, right? The logic of the court's intervention. And that's why I use those two categories of cases, because category 1 will cover every breach of duty. Every breach of duty will cover category 1. Then category 2 will cover direct dealings, right? Right? But so long as you remember the break being that you cannot use 994 to make bargains for people. 994 is not an instrument for distributive justice. It is an instrument for corrective justice. Okay, and then in terms of the relief you get, again, the relief is wide. The court can do anything. If you notice, it says the relief under 996 for the court to make such order as it thinks fit for given relief in respect of the matters complained of. But without prejudice, it can do other things, such as asking for the purchase of the members' shares under subparagraph E. And then, now, when we get to category 2 companies, you will see that the answer is in the relationship agreement in the listing rule 6.14. So it requires a new applicant for admission to for the admission of equity shares to a premium listing to demonstrate that it will be carrying on an independent business as its main activity, right? So the idea basically is that you need to have a requirement in place with the controlling shareholder containing prescribed independence conditions. In other words, I'm referring to your relationship agreement. And you might want to look at the article here by Iris Chu and Barker, where they talk about protecting minority shareholders in block-controlled companies. And notice the quote there that I take from it. It says, the new regime is introduced with the same ethos in relation to preserving the independence of business, in this case with respect to controlling shareholders rather than management. Controlling shareholders rather than management. Management is your typical agency cost, right? The Code of Corporate Governance focuses on managers. This focuses on controlling shareholders, right? So, and when he says, the same ethos, it's referring to the ethos with which the Corporate Governance Code has been developed, right? Okay. Now, having said that, now we know. So that's a full discussion of the unfair prejudice. What I want you to recall when you look at the derivative action, which I've talked about, what I want you to recall, again, I want you to understand the logic of it. And the logic is what I've just basically talked about in regard to the unfair prejudice one. The logic is this. Separate legal personality, right, means that if the company is wronged, the company should sue, not any other person. So if you are going to be permitted to sue on behalf of the company, you're asking the court to dismantle separate corporate liability, right? Or separate corporate personality. You're saying to the court, override it. Now that's very serious. You're telling the court to override separate legal personality. So the question for the court is to say no. Well, the answer to the court is to say no, we're not going to override it. But that's a formalistic answer. Under certain circumstances, the court will grant an override. The court will grant an override if it concludes, in my view, that there has been governance failure. Now, so what I have set out in your seminar sheet or in this document from page 10 is my theoretical take on what's going on. And you can compare this to Gower. Gower simply looks at the provisions. I don't just look at the provisions. What I try to put forward is a theoretical take. And I'm basically saying that the question for the court, right, is should we do an override? Right? Separate legal personality means that we cannot dismiss the right of the company to sue. And therefore, if you come to sue on behalf of the company, we say no. It's separate legal personality. It goes back to Solomon's case, to Foss and Harbour. However, what if the company, right, is being mismanaged by the bad guys, the guys who will never sue themselves? Because guess what? They have the power to sue, and they're not going to sue themselves. So the question for the court then is to say, should we grant an override? Think about Theopaphitis. When they brought the derivative action claim, the court had to ask the question, should we grant an override? Should we override the board of Theopaphitis and permit you to sue on behalf of the company? Now, to decide this question, you have to ask the question, has there been governance failure? This is the idea I'm bringing in. Has there been governance failure? If you conclude that there has been governance failure, then you override them and permit the shareholder to bring a derivative action. If, on the other hand, you say there has been no governance failure, then you do not permit it. So in the case of Theopaphitis, we concluded that there was no governance failure. Why? Yes, what Theopaphitis did was bad, but the board, they were sensible. They realized that if we bring this action, the reason why we're not bringing this action is because we're going to harm ourselves. If we bring this action, sue Theopaphitis, Theopaphitis is still going to make all the money, right? So we, as a board, decided not to sue. We decided not because we are bad, not because there was governance failure, but because in the end we concluded there was no point throwing good money after bad. So the entire structure in Part 11 is to really work out the question whether there is governance failure. So when you read from page 10, and you see I've signposted it, when you read from page 10, yes, so this is page 10. So you see here I talk about the challenge of any legal system, right? The challenge of every legal system. And I say the starting point here is separate legal personality. Then the dilemma at the heart of every system of company law. This is the dilemma that every system of company law has to deal with. And then I say, here I then say, so what happens when there's governance failure? What happens when there's governance failure? And here I use governance failure to denote the circumstances where an override of one organ is permitted to occur, right? And essentially, I say the override should not be automatic. There should be guidelines for this. And those guidelines are what we see in the Companies Act, right? And so by the time you get to the procedure, right, which I essentially discussed with the case law, so I've introduced the procedure and the case law. It's all straightforward. You now understand the framework. So the framework is separate legal personality, which we've got to respect, formalism, blah, blah, blah. Should we grant an override? And if we're to grant an override, what's the procedure? That's it, right? Okay, so we'll stop here. So what I've done, very quickly, by the way, obviously, remember we had the problem-solving class and all that, where we went through things. So that was a slight alteration to our schedule of seminars. So one of the topics which I wanted to do, because what I've done, I've collapsed two topics here, but one of the topics which I wanted to cover, we obviously have not had time within the schedule of seminars to cover that. One approach could be that I do it at some point when you come for revision next year, or we just go straight into revision classes. Somehow my sense is that people would prefer to just go straight into revision classes. I could do it and not examine anything on it, right? So I think that probably would be the best. I'll do a class and I will not examine it, but just so that you understand what I mean by the issues, and then still hold the revision classes. So that way you get that extra. The extra, when I say extra, it should always be there. You get that bit, but you're not examined on it, right? I think that probably would be the best. So thank you very much, and I hope you enjoyed it. Cheers. Thanks. Thank you.
Do you have any idea of the dates of these classes or the proper exam, or when it's going to be published?
No, it will be published maybe about, let's say, when the time, just before the exam time comes out.
Because it's usually on May, right?
Yeah. So it will be.
Because I know that for some others they do it on April.
No,
they kind of
it'll be May. Okay. And the normal exam. So what we'll do, we'll schedule.
Probably like a month.